Amendment to the Indian Constitution. Introduction. Like any other written constitution, so when there is a written constitution, that constitution needed to be amended. It needed to be amended. The Constitution of the India, it provides for the amendment to adjust itself to the changing conditions and the needs. It is neither flexible nor rigid. Neither flexible because the amendment process is very difficult, nor rigid because there is an amendment process. The Constitution allows for amending itself. Right. Article 368 in Part 20 of the Constitution. The most important article is Article 368. This is in the Part 20 of the Constitution. Part 20. It is the power of the Parliament. The Parliament is having the power to amend the Constitution and procedure. So we have the power of the Parliament. Parliament is having the power, right? Parliament can amend the Constitution. To amend the Constitution. And the procedure related to amending the Constitution is specified in Article 368. Article 368 mentions Parliament having the power to amend the Constitution. Parliament can, we say, it can add, change or repeal any provision of the Constitution in accordance with the procedure. This is a potential MCQ. It can add, it can change, and then it can repeal as well. What is meant by addition? For example, if there is A, Parliament adding is A is addition. Repealing means deleting A. If there is A, B, C, it is deleting C, repeals B, and AC alone is present in the Constitution. Change means it's A, B, C, right? It is bringing B out and keeping it separately, just inducing some changes. Let it be D instead of B, right? So it can adding, repelling. Adding, repel means deleting. So repel means deleting. And then we also have the change. Now, in case 1 in the Bharati case, the Parliament cannot amend the basic structure of the Constitution. Is there anything the Parliament cannot amend? The Parliament, is there anything it cannot amend? It cannot amend. The Parliament cannot amend the basic structure. Amend basic structure. And what is the procedure for the amendment? For amendment, the bill needs to be initiated in either of the house. It can be Lok Sabha or it can be Rajya Sabha, and it is the Parliament alone and not the state legislatures, right? The bill for amending the Constitution, the bill is initiated in either of the house. It cannot be initiated in the state legislature. Both the private members and then the minister can initiate a bill. Constitution amendment bill can be by the private member as well. A private member can initiate a constitutional amendment. It does not require prior permission of the president. The most important fact over here is, can private member? Yes. Private member can initiate a constitutional amendment bill. Should pass the house with a special majority. Special majority is 50% of the members should tell yes, and 2/3 of the members must vote, must present, and they must vote. In 2/3 of the members, so 2/3 is 33, 33, 33 is what? 3. 2/3 is 66.66 is what we have, 2/3. 66 members of the entire 100% must vote for it. And out of the 66, you have to get 50%. Right? 66%, you have to get 50%. There is no provision for joint sitting. Half of the states needs to ratify the bill with a simple majority in case it intends to amend a federal provision. Half of the state in itself. Right? We have mentioned that half of the state. It is half of the state must sit and they must ratify. the bill. This is with a simple majority. Half must sit and ratify with a simple majority, in case if it is amending a federal structure. After passed, bill is presented to the president must give assent under 24th Constitutional Amendment Act of 1971. So he must give assent in the 24th Constitutional Amendment Act. He must give assent under the 24th Constitutional Amendment Act and cannot withhold means reject the bill. Withhold in the sense it is rejecting the bill, and he can neither amend the bill, return the bill, withhold or return, reject or return. He must give assent. After the president assent, the constitution stands amended. What are the types of the constitution? By a simple majority. It is not deemed to be an amendment under Article 368. An amendment by a special majority. Amendment by special majority plus ratification of half of the state legislatures. Such amendments do not require Constitutional Amendment Act. For example, Lok Sabha, out of 545, 45 were absent and 100 abstained from voting. 400 members only are present and voting. Out of these 400, the number of members present and voting, simple majority requires 201 itself. Can be used for provisions like admission or establishment of new states. It is used for what are the provisions in which simple majority is used when we are having a new state, right? So when we are having a new state is where simple majority is being used. Formation of the new state. Article 2, formation of new state. Article 3, alteration of the boundaries of existing states. Article 2 and Article 3, abolition or creation of the legislative assemblies. Schedule, second schedule is related to the emoluments, allowances, privileges and so on of the president and the governors, the speaker, judges. So we have what is present in the second schedule. Is the salaries and allowances, privileges of the president. Here who is coming? We have to remember the president, governor, speaker, judges, etc. So when it is related to Article 2, Article 2 is the admission or establishment of new states. Admitting or establishing new state, and Article 3, formation of the new state. Admission, establishment, forming a new state, alteration of the areas, boundaries and names of existing states, abolition and creation of the legislative councils in the state. And second schedule, quorum in the parliament, 1/10 is the quorum as of now. Salaries and allowances of members of the parliament and rules of procedure in the parliament. Privileges of the parliament, its members, its committees are having certain privileges, right? Use of English language in the parliament and number of puny judges in the Supreme Court. Containment of more jurisdiction on the Supreme Court, use of official language, citizenship is very important. Citizenship is by the simple majority. Election to the parliament and the state legislatures, delimitation and elections, delimitation, union territory. Fifth schedule, admission of scheduled areas and tribal scheduled tribes, admission of tribal areas. Sixth schedule. So fifth schedule and sixth schedules are going through the simple majority. Now what is the special majority? Is Article 368. It refers to the majority of 2/3 of the members present and voting, and it is supported by 50% of the total strength of the House. This is chiefly used for most of the Constitution Amendment bills. And passing the Constitutional Amendment Bill which does not affect federalism. The provisions that can be amended are fundamental rights, DPSPs, instances where this type of majority is used other than Article 368. Removing the judges of the Supreme Court or the High Court. And removing the Comptroller and Auditor General or Chief Election Commissioner. So the removal of the CAG and the Supreme Chief Justice Chief Election Commissioner is similar to the Supreme Court judge. Right. So the removal of Supreme Court judge and High Court judge are similar. The removal of CAG and ECE are similar to the Supreme Court judge. National Emergency Resolution by the state legislature for abolition or creation of the legislative council. So what are the conditions for removing? Well, we are having the special majority, right? Then special majority plus 50% ratification is necessary when we are changing the federal structure. There is no time limit in which the state must respond. There is no time limit which is mentioned in the constitution itself. So no time limit which is mentioned. No time limit is mentioned in the constitution. Once affirmative response of half of the states is received, the response of rest of the state doesn't matter whether negative or positive or withheld. The bill introduced the National Judicial Appointments Commission. It needed the support of 15 state legislatures out of 29. Provisions that can be amended in such a way are election to the president and its manner, executive and the legislative power of the union and the states, Supreme Court, High Court, distribution of the legislative powers between the state and the unions, 7th schedule, and representation of the states in the parliament. Article 368 itself. And what requires absolute majority? What is meant by absolute majority means 50% of the total membership of the house. So 50% of the total membership is 545 is the total members divided by 2. So 250 plus 20 plus 3. 273 is the absolute majority. 273 must tell yes to the bill. This majority was never used anywhere but has a significant. If a political party has absolute majority, it means that it can form the government. There is a stability in the house. Effective majority is 50% of the effective strength of the house. This eliminates the vacant seats. This means that the effective strength of the house is 545 minus 5 is 540. No vacancies. Vacancies arises due to 3 reasons. Right. So the number of vacancies. The vacancy arises due to 3 reasons: death, disqualification, and resignation. Either they are died or they are resigned individually. Then they are disqualified. Death, disqualification, and resignation. The source will be having same source of. Some sources mention absenteeism as a vacancy, but that is incorrect. In the constitution, an effective majority is mentioned as all the then members. It is for the removal of the Rajya Sabha deputy chairman and removal of the deputy speaker of the Lok Sabha, and then we have the state legislatures. Right. Removal of the deputy chairman in the Rajya Sabha. Article 67B. And then we have the removal of the speaker, deputies, all the deputies of the Lok Sabha and the state legislature. Special majority is in Article 61. It comprises 2/3 of the total strength of the house. Special majority is used. This majority is used for the impeachment of the president. 2/3 of the total strength of the house. That is 2/3 members must tell yes to the bill. The special majority under Article 61 and special majority under Article 249. Majority of 2/3 members present and voting. This is used to pass a Rajya Sabha resolution to empower Parliament to make laws in the state list. Amendment procedures has been criticized that there is no special provision like a constituent assembly or constitutional convention as in USA. Constitutional assembly for amending the constitution. The constituent power is vested in the parliament and only in few cases in the state legislature. The power to initiate an amendment to the constitution lies with the parliament. Hence, unlike the USA, the state legislatures cannot initiate a bill or any proposal for amending the constitution except in one case, that is passing a resolution requesting the parliament for creation or abolition of legislative councils in the state. Hence, here also, the parliament can either approve or disapprove such a resolution or may not take any action on it. A major part of the constitution can be amended by the parliament either by special majority or simple majority. Only in few cases the consent of the state legislature is required, and that too only half of them, while in the USA 3/4 is required. The constitution does not prescribe a time frame for which the state legislature should ratify or reject the amendment submitted to them. Also, if it is silent on the issue whether the states can withdraw their approval. There is no provision for holding a joint sitting to both the houses of the parliament if deadlock over passage of the Constituent Amendment Bill. On the other hand, a provision for joint sitting is made in case of an ordinary bill. The process of amendment is similar to that of the legislative processes. Except for the special majority, the constitutional amendment bills are passed by the parliament in the same way as ordinary bills. They leave a wide scope for taking matters to the judiciary. Constitutional amendment procedure can be initiated by, in the USS, it can be initiated by both center and in the state. Amendment by the center. Amendment can be initiated in any houses, either the House of Representatives or the Senate, in case of USA. For the center to amend the constitution, it must be amended with the 2/3 members present and voting. If the amendment is then sent to the state, the amendment would come with a ratification of 3/4 of the states. Basic structure of the constitution. The basic structure, whether fundamental rights can be amended or not, came into force the two amended by Article 368 came for the consideration of the Supreme Court within a year of constitution coming into the force. So the question whether fundamental rights can be amended or not by the parliament under Article 368 came into the consideration of the Supreme Court within 1 year, just within 1 year of the constitution coming into force. The first case over here is Shankari Prasad case 1951. The second related is Golaknath case 1967. And the third case is Keshwananda Bharati case. And fourth case is Indira Gandhi case. So we are seeing here fifth case as Minerva Mills case and sixth case as Vaman Rao case. Golaknath case. Before that we have Shankari Prasad case. Shankari Prasad case relates to the constitutional validity of the first Constitutional Amendment Act, which curtailed the right to property by inserting the Schedule 9 into the Constitution, and Article 31B are related to the 31B, and even Article 31A are related to the first Constitutional Amendment Act. Supreme Court said that the power of the Parliament to amend Constitution includes the fundamental rights. Yes. In Shankari Prasad, it says yes. That is why we have the Schedule 9 and Article 31A and 31B. The Parliament is having the power to amend the constitution. And law, the term law under Article 13, it includes only the ordinary laws. It does not include the Constitutional Amendment Act. It includes only the ordinary law. And it does not include the Constitutional Amendment Act. Next thing is the Parliament can abridge or take away any of the fundamental rights by enacting the Constitutional Amendment Act, and it will not be a void of Article 13. In Shankari Prasad, yes, the parliament can amend using 368. Law does not include the Constitutional Amendment Acts. Now, in Golaknath case, 17th Constitutional Amendment Act included the more acts under 9th schedule, removing them from the scope of the judicial review. So, Parliament cannot amend them, and law includes constitutional. Opposite, reverse to the Shankari Prasad case is the Golaknath case. So, we have yes in S368 and no constitutional amendment under law in the Shankari Prasad case. And next we'll be having the Golaknath case. No, it cannot amend under 368 because law includes Constitutional Amendment Act. Golaknath case in 1967 is opposite to the Shankari Prasad case in 1951. So far we have seen two cases. Therefore, the Constitution has enacted the 24th Constitutional Amendment Act, which made changes in Article 13 as well as Article 368. 24th Constitutional Amendment Act has made changes. So the 24th Constitutional Amendment Act changes in Article 13 as well as we have the Article 368. Article 13 and Article 368. The Parliament's reaction will be having the Article 24th Constitutional Amendment Act. So 24th Constitutional Amendment Act of 1971. We have it and amended Article 13. Constitutional amendment is not a law under the definition of Article 13. Constitutional amendment is not a law under the definition of Article 13 and amended Article 368. Parliament is having the power to abridge or take away the fundamental rights. Parliament can take away the fundamental rights. Now, Shankari Prasad case in 1951. Yes. Golaknath case in 1976. No. This is related to Article 13 and Article 368. As this Parliament can amend using Article 368 and law does not include Constitutional Amendment Act. No means Parliament cannot use Article 368 to amend the Constitution and law includes Constitutional Amendment Act. Now it has changed the words of Article 13 and Article 368. That is why for 24th Constitutional Amendment Act 1971, we have Keshwananda Bharati case of 1973, 24 April 1973. The Supreme Court has overruled its Golaknath judgment. Article 24 has been upheld. The Parliament can take away the fundamental rights, but it created a doctrine of basic structure where Parliament cannot alter the basic structure under Article 368. Now, Indira Gandhi case in 1975, based on the doctrine of basic structure, invalidated the 39th Constitutional Amendment Act, which kept the election disputes of the Prime Minister and the Speaker of the Lok Sabha outside the jurisdiction of the Supreme Court. So, we have the 39th Constitutional Amendment Act of 1975. This is Indira Gandhi case. Indira Gandhi case is 39 Constitutional Amendment Act of 1975, which kept away the election disputes. It kept away the election disputes involving the Prime Minister and the Speaker of the Lok Sabha outside the jurisdiction of all the courts. It kept away it outside the jurisdiction of all the courts. 39th Constitutional Amendment Act 1975 is the one which has been invalidated, and what has been kept outside the jurisdiction? Elections to the Prime Minister and the Speaker of Lok Sabha. What is the Parliament's reaction? Again, 42nd Constitutional Amendment Act, which amended Article 368 and declared that there is no limitation on the constituent power of the Parliament. But this amendment cannot be judicially removed and the amendments cannot be judicially reviewed. This is under the 42nd Constitutional Amendment Act of 1976, where it amended, and the amendments under the Constitutional Amendment Acts do not include the judicial review, but it was invalidated in the Minerva Mills case of 1980, where we be having judicial review is a basic feature of the Constitution and Parliament cannot abrogate it. Parliament has limited power to amend the Constitution and its limited use to give itself, and it cannot use this limited powers to give itself an unlimited power. And then we have the Vaman Rao case. Now, when we are recapping the Minerva Mills case, this is 39 Constitutional Amendment Act of 1975 under the Indira Gandhi case, 1975, where we will be having that the election disputes are kept away. Now, in order for election disputes and this Indira Gandhi case, again 42nd Constitutional Amendment Act, where the Constitutional Amendment Acts cannot be judicially reviewed. In the Minerva Mills case is where the Supreme Court is telling that it cannot use its limited power to give itself an unlimited power. The basic structure doctrine applies to all the Constitutional Amendment Act which are enacted after 42nd Constitutional Amendment Act 1973 after the Keshwananda Bharati case judgment. The elements is going to include, there is no fixed element such as the basic structure, whereas Supreme Court is yet to define and clarify. From the previous judgment, supremacy of the Constitution, sovereignty, democracy and republic nature of the Indian polity, secular character of the Constitution, separation of the powers, there is a separation of the powers between the legislative, executive and the judiciary. Federal character of the Constitution in the S.R. Bommai case. Unity and integrity of the nation, welfare state and socio-economic justice, judicial review, freedom and dignity of the individual, parliamentary system, rule of law, harmony and balance between fundamental rights and directive principles, principle of equality, free and fair justice, independence of the judiciary, unlimited power to the parliament to amend the constitution, effective access to justice, principles or essence underlying the fundamental rights, powers of the Supreme Court under Article 32, judicial review, 136, 141 and 142. High Court powers is 226 is judicial review and 227.